Let's go ahead and get started. Good afternoon and welcome to the Committee for Justice's virtual panel discussion, Agency Independence, Presidential Power, and Seila Law versus CFPB. I am your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. Today we have with us some exciting panelists who will have a very interesting expert insight on the Supreme Court's recent decision. I will now introduce our panelists in the order in which they will be speaking. Adam White is a resident scholar at the American Enterprise Institute and an assistant professor at George Mason University's Antonin Scalia School of Law, where he directs the Steve Winning Gray Center for the Study of the Administrative State. In 2012, he was part of the team that filed the original constitutional lawsuit challenging the CFPB's independence. Ilya Shapiro is the director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute and publisher of the Cato Supreme Court Review. Before joining Cato, he was a special assistant and advisor to the multinational force in Iraq on rule of law issues and practiced at Patton Boggs and Cleary Gottlieb. Shapiro is co-author of Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution, and editor of 11 volumes of the Cato Supreme Court Review. He has contributed to a variety of academic, popular, and professional publications and regularly provides commentary for various media outlets. Shapiro has testified before Congress and state legislatures and has filed more than 300 amicus briefs in the Supreme Court. Beau Brunson is the Director of Policy and Regulatory Affairs at Consumers Research and leads Consumers Research engagement on legislation and regulation. His work includes research on financial product sandboxes, public interest comments on modernizing banking and energy regulations, and numerous consumer-focused editorials on issues pertaining to consumer protection, financial services, technology, and copyright issues. Prior to Consumers Research, he served as Deputy Chief of Staff and Legislative Director for a member of Congress, serving on the House Committee on Financial Services and Chairman's designee to the House Committee on Space, Science, and Technology Subcommittee on the Environment. A few housekeeping notes for if you want to send a question during our Q&A portion, please send it to me directly through the Q&A function on Zoom. You can send me those questions at any point throughout the panel, and I'm going to weave those in towards the end of our discussion segment. And that's pretty much it. So with that, Adam, the floor is yours.
Well, thanks. Thanks for inviting me. It's a pleasure to be here with friends and talk about this case. I think this week's decision was a great win for the Constitution and an important case. I'll set the table for the case and then turn over to Ilya. But just by way of background, if you go back in time a decade to when the CFPB first started being proposed, it's fascinating to go back to those early articles by then Professor Elizabeth Warren and see how mundane the agency was supposed to be. She originally proposed she modeled the CFPB on the Consumer Product Safety Commission, a multi-member, 5-person bipartisan commission that would regulate consumer financial products. And in other writings, she warned that it would be important for this agency to sort of set rules in advance, not use enforcement or adjudication as a hammer for making law on a case-by-case basis. It was really sort of a mundane, sleepy agency. One can, criticize whether the federal government needed to play that role at all, whether it was better left to the states. One can question whether independent agencies are ever a good thing. But as far as, things generally go, the originally proposed CFPB was basically going to be the next, CFTC. Well, by the time that Dodd-Frank was actually enacted, of course, it got turbocharged into something very different. They got rid of the multi-member commission structure, made it just one director. They gave it an immense sort of independent source of funding rather than going to Congress with Congress's power of the purse and not working through the president's budgetary role. They just gave the CFPB a blank check every year, hundreds of millions of dollars from the Federal Reserve. And then there were a variety of other sort of small little features, all intended to make this really the most independent agency that we've ever seen. At the same time, the agency would have basically open-ended regulatory powers. There are a couple other novel things that were thrown in, some ways in which another new body, the Financial Stability Oversight Council, would have a limited oversight role over the CFPB. But this thing really was unprecedented. And so it left its critics with real questions about how, if at all, to challenge it. Ashley kindly mentioned that I was involved in an early lawsuit. It's not the one that wound up going to the Supreme Court, not at all. We filed, when I was working with Boyden Gray, we and O'Melveny and Myers and CEI filed a lawsuit on behalf of a West Texas community bank that wound up getting dragged down into procedural limbo. But in any event, when we were framing up the case, the real challenge was how to frame it, because you had this unprecedented combination of features that really put it beyond the bounds of anything the Supreme Court had ever approved, but there wasn't an obvious box to put it in. We thought about the non-delegation aspects of it. We thought about Congress's power of the purse. We thought about the multi-member commission structure. Ultimately, our own case was framed in terms of sort of a mosaic theory, that when you put all these pieces together, it goes beyond anything that the Supreme Court had ever signed off on before. And our hook for that, and ultimately the hook for the Supreme Court in its decision, was the fact that right before Dodd-Frank was passed, the Supreme Court drew a dotted line around the current independent agencies. In the case of Free Enterprise Fund, it was the challenge to Sarbanes-Oxley's independent agency within an independent agency. Chief Justice Roberts' opinion for the court basically said that the Supreme Court had signed off on some limited exceptions to the usual rule of presidential control of agencies, and the court wasn't going to allow any further creativity beyond that dotted line. And so that was always, I think, in our case, in the PHH case that Ted Olson argued, and then in the ultimately successful Seila Law case, and another case called Morgan Drexen, we kept focusing on this combination of factors, combination of structural factors, and the fact that it really was beyond anything the Supreme Court had ever affirmed. That strategy didn't require the courts to go back to first principles. It just asked the court to enforce the limited lines that were already drawn. The CFPB, in the meantime, I'll just wrap on this, it really did prove its critics right at every point along the way. When Richard Cordray got his initial recess appointment and went on a flurry of public speaking and regulatory actions, he told a member of Congress in a hearing that it wasn't any of their business how the CFPB was spending immense sums of money on its own building. He said in another hearing that the CFPB would not try to define its broad statutory terms in advance of enforcement. It would just sort of make up these interpretations as it went on a case-by-case basis. Cordray said he didn't think it would be helpful for the agency to make these decisions in advance. Helpful to whom? Well, helpful to the CFPB, of course. Elsewhere, in other hearings, he said the CFPB had broad power to waive other statutes that were inconsistent with the CFPB's regulations, and on and on. The early CFPB really was a perfect case study in why accountability and structure is important in our Constitution. And I think that really helped lay the groundwork for the lawsuits that ultimately succeeded in pulling back some of that independence. So maybe with that, I'll turn it over to Ilya so we can talk about the case.
Great. Well, thank you, Adam. This case involved a law firm that advised various clients on consumer finance issues. There was an investigative demand that the CFPB issued about some of its practices, and in response, in part, Seila Law challenged the constitutionality of the structure, ultimately losing before the Ninth Circuit, but the Supreme Court in a 5-4 ruling overturned or reversed that ruling, holding that the structure of the CFPB violates the separation of powers, but that the CFPB director's removal protection is severable from the other statutory provisions bearing on the CFPB's authority. The agency may therefore continue to operate, but its director must be removable by the president at will. I was quoting there directly from the opinion. So that's an opinion by Chief Justice Roberts, joined at least in the judgment by the other 4 Republican appointees, or at least in the judgment that the CFPB's structure is unconstitutional. Only Alito and Kavanaugh agreed with the chief that the removal protection is severable. The dissenters, the Democratic appointees, also agreed with that, I guess grudgingly, since they got half a loaf in that regard. Justices Thomas and Gorsuch would have overruled Humphrey's executor, which I'll go into in a moment, and disputed also the severability doctrine altogether. In fact, Justice Thomas would have gone both more broad in terms of overturning Humphrey's executor and more narrow in terms of the remedy as just not enforcing the investigative demand. So what the plurality opinion was holding, or I guess the majority at this point before we get to severability, while we need not and do not revisit our prior decisions allowing certain limitations on the president's removal power, there are compelling reasons not to extend those precedents to the novel context of an independent agency led by a single director. That is, as Adam was describing, these other independent agencies were different in various ways. They were totally independent, but they were multi-member, or they were a single director, but not fully independent, or the scope of their rulemaking power wasn't quite as fully discretionary as with the CFPB. In short, this is back to Robert's opinion, Humphrey's executor permitted Congress to give for-cause removal protections to a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. But this is page 23 of the slip opinion. The resulting constitutional strategy is straightforward. Divide power everywhere except for the presidency and render the president directly accountable to the people through regular elections. In that scheme, individual executive officials will still wield significant authority, but that authority remains subject to the ongoing supervision and control of the elected president. The CFPB's single director structure contravenes this carefully calibrated system by vesting significant governmental power in the hands of a single individual accountable to no one. The director is neither elected by the people nor meaningfully controlled by someone who is. The director does not even depend on Congress for annual appropriations. As an aside, I think that's a very important point. This is kind of a, we talk about the bureaucracy being a fourth branch of government. This is essentially a fifth or a sixth. It's kind of once it was created, it's a perpetual motion machine. So anyway, Roberts continues, the director may unilaterally, without meaningful supervision, issue final regulations, oversee adjudications, set enforcement priorities, initiate prosecutions, and determine what penalties to impose on private parties. With no colleagues to persuade and no boss or electorate looking over her shoulder, the director may dictate and enforce policy for a vital segment of the economy affecting millions of Americans. And therefore, the removal protection is enough to render the agency structures unconstitutional, but the 5-year term and receiving funds through the Fed, not appropriations process, makes it even worse. As Roberts concludes that section, the president's removal power is the rule, not the exception. The court rejected the argument that the removal protection could be interpreted to give the president substantial discretion. And so at that point, Thomas and Gorsuch peel off. Roberts, Alito, Kavanaugh go on to say that there is severability, thinking about what would Congress that passed Dodd-Frank preferred. No agency at all, or that the agency that they created, but with removal protections, not quite as independent as they wanted, because as the court just described, that measure of independence is not allowed. You can't simply create a new branch of government. Justices Thomas and Gorsuch concurred in part, dissented in part. First, they said that Humphrey's executor, which allowed these independent multi-member commissions, said that Humphrey should be overruled. The decision, quote, poses a direct threat to our constitutional structure and as a result, the liberty of the American people. Congress has increasingly shifted executive power to a de facto fourth branch of government, independent agencies, and our tolerance of independent agencies is an unfortunate example of the court's failure to apply the Constitution as written. It goes on to say later on, quoting or citing the important precedent that we've had in this area the last 25, 30 years, Morrison versus Olson, Free Enterprise Fund, involving the something that Sarbanes-Oxley created, the Public Companies Accounting Oversight Board. And now this case, the foundation for Humphrey's executor is not just shaky, it's non-existent. And then when we come to severability, Thomas disagrees with doing that the way that the plurality joined effectively by the dissenters did, because it means that courts are revising and rewriting statutes. They should just refuse to enforce any of the agency's demands or actions and let Congress handle the rest. Briefly, in dissent, this was written by Justice Kagan, with all three of the other more liberal justices joining. First, says that on constitutional text, history, precedent, structure, and policy, the president has zones of administrative independence, limiting the president's removal power. The president, in effect, has more, not less control when there's a single head director rather than multi-member. So, the CFPB under this ruling is less problematic than, say, the SEC or the CFTC, as Adam was describing, or the CPSC, all the alphabet agencies. The separation of powers is, quote, by design, neither rigid nor complete. And so the CFPB is not unconstitutional, even though it's novel. Novelty is not the proper test. Congress regulates in that sphere under the necessary and proper clause. And given the modern challenges of the modern economy and the issues faced in the financial crisis, this is a totally understandable, necessary, and proper result. So I'll end with that, and happy to talk further about what I think the consequences of this might be for other agencies or the CFPB itself.
Beau?
Thank you, Ashley, for allowing me to come on. I'm gonna take a different tactic. I'm not a constitutional lawyer by any stretch of the imagination, and so I'm going to stay out of that field. But I'm going to talk a little bit about what this means for consumers. Kind of something that I think is often lost in the discussion of the CFPB is what was the world like when it was passed? Coming out of financial crisis. And some sort of desire for overwhelming consumer protection, and I like to mark this because Dodd-Frank passed, CFPB created July 21st, 2010. 3 days later, the iPhone 4G was released, and I think that's significant because the iPhone 4G was really the first place where consumers we're no longer going to have to go to their banks. And so in 3 days after the passage of Dodd-Frank, the entirety of consumer banking changed. We didn't know it yet, but now, 10 years later, that's where we are. Consumers bank in their pocket. Consumers don't have to go and talk to their bankers. Things move a lot faster. And so here you have this agency that has basically been given supreme power over consumer financial protection that was drafted through legislation that doesn't exist in the modern era, or basically a consumer protection regime that doesn't exist now. And so one of the reasons that I felt like it was really important to stake this claim, the Seila Law case, was that if you had a single director over the course of the entirety of a presidential administration not aligned with parties, the shift couldn't occur. And so innovations that changed, other things like that would boost consumer access changed. The director wouldn't have to change it in that sense. And so here you have this single director funded by the Fed, completely and totally independent. And what did the original director do? He set out to do exactly what he said and tried to turn the whole world on its head. And you have a new president turn over. The director the director there basically sits and over the course of the first year of the next administration continues to focus his views on consumers rather than the president. And so in that sense, it's good for consumers because consumers have a voice in the say of the policy in the case of an overlap. New director comes in and there's a change in philosophy. There's a rollback of the arbitration rule. There's a rollback of the payday rule, or at least attempt creation of a new innovation office. And so I think where we are now is with a administrator that is answerable to the president. There is an opportunity for consumers to weigh in a little bit more, and a point that maybe didn't exist. You basically had the CFPB, they were going to do what they were going to do regardless of what consumer sentiment was. You almost had a consumer financial Politburo rather than a consumer financial protection bureau. And I think that's going to change in the short run. In the long run, in some ways we're exactly where we are now or where we were before. And I think that's unfortunate. Mulvaney, when he became the acting director, he said the CFPB is here to stay. And so the goal from here on out is to make the CFPB work for everyone. So how do we do that? Well, with the funding structure still the way it is and the leadership structure still the way it is, there is no push and pull with Congress. And every member of Congress represents hundreds of thousands of people. And so, yes, you have the supporters of the president that are represented, but the other half really have minimal say. The director has to come to Congress and give each House of Congress a talk, a meeting 2 times a year, doesn't have to answer questions. It was very frustrating when I was a staffer with the previous director or the first director. Even if we weren't being combative, if we were trying to work with the director, he didn't have to do that, and he wouldn't. I was there when he said in the room when Richard Cordray said it's none of your business how we're spending our money on our building. That's a problem, and that continues to be a problem. And so I think that the next steps need to be, one, put the CFPB on the appropriations process. In some ways, I'm going to use a metaphor from Parks and Rec, but the director of the CFPB gets to be the Mona Lisa Saperstein of agency directors. He just sticks their hands out, says, "Money, please," and the Fed has to, and that's problematic. When during the budget process, staff from the agencies go and they sit in front of Congress and they argue back and forth, and the staff and the staff and the members of Congress hash out things. If agency regulation isn't going the way that one party wants, there's a lot more opportunity for pushback, for consumer feedback. And so I think that's important because the way that it is funded right now, that doesn't have to occur and won't occur. The other thing, we talk about and bipartisan leadership structure. As long as the world exists the way it does today, unless there's another Supreme Court ruling, I think you look at the other agencies, the FCCs, the FTCs, the CFTCs, there is a lack of leadership vacuum. There is no leadership vacuum in those when there's a change in political power. Everybody stays working, and so there's an opportunity for, number one, for when there's a changeover, for things to move forward. But number two, there's an opportunity for more discourse on regulation. And I think that's important. You think about it, when Mulvaney came into power, the CFPB just stopped. And basically the same thing happened when Craniger came in. The CFPB stopped again, and they were from the same political party. And so stopping this organization that's meant to protect consumers, regardless of philosophy, when that just stops on a dime, that's problematic. And so I think, in the sense that if you want some sort of continuity so that you don't have the same sort of leadership vacuum, a bipartisan board is appropriate. And so I'm happy to talk a little bit more about that, what we do in the future going forward. And thank you again.
Thank you, Bill. So the first question for our panelists as we start this discussion, I think it would make sense to talk a little bit about the other litigation and what could potentially happen in the courts next, because there's a lot out there. There's still the lingering question of the fact that the CFPB is funded by the Federal Reserve. And I also think, we have at least a solid 3 justices on the court who would very much like to grant another petition should it come up, within the next couple of years. Where do you all see this going?
Well, I'll jump in. I know there's at least one lawsuit out there challenging the funding structure. I think it might be by Philip Hamburger's NCLA. So that's out there. I'd say, looking at this case, and I have a piece coming out about this, probably it'll probably come out next week on City Journal's website, about the way that what this court's opinion does and the groundwork it lays. There's a couple of paths that it could take towards further reform. The first and most obvious is just direct rollback of the 2 main precedents at issue, Morrison v. Olson and Humphrey's Executor. As in this opinion, we saw it, or in Thomas and Gorsuch's opinion in the case, we saw real interest in rolling both of those back, getting rid of them, just restoring all federal agencies to direct presidential control. Kavanaugh didn't join that opinion, but he has said elsewhere, he said when he was on the DC circuit in a pretty candid interview at AEI, where I now work, he said that he'd love to put the final nail in the coffin of Morrison v. Olson, the independent counsel statute. Now, one of the great things about this case, the new case, is that it really imposes some structure on this confusing area of agency independence. It says there are two exceptions to the general rule of presidential control. One, for inferior officers, there can be some statutory independence under Morrison v. Olson, the independent counsel case. And then for the heads of agencies, independence has to be limited to these multi-member commissions. Kavanaugh's focused on the Morrison point, less so on the Humphreys point. And what's interesting is you could see the court, instead of going for a full rollback of agency independence, another course that's maybe, you see the groundwork here in Seila, is to roll things back to Humphrey's Executor, which is to say, and the line here, the way that the court describes the Humphrey's Executor precedent is this exception to general presidential control for multi-member expert agencies that do not wield substantial executive power. Now, in the Humphreys case, almost a century ago, it was the FTC. And Elena Kagan, in her dissent here, says, well, the FTC, this is a rewriting of history. The FTC has always had, what looks like executive power, the power to bring enforcement actions and so on. Roberts and the majority say, well, we take that case on its face. And in that case, the whole reason why the court upheld the independent structure for the FTC was that they didn't see it as an executive body. In fact, they said it was charged with no executive power other than administering the policy of the statute. The past is a foreign country. If you go back to the era of Humphrey's Executor and beforehand, these independent commissions were really seen as adjuncts or replacements for district courts. It was the whole point behind the Interstate Commerce Commission, the FTC, and the other early multi-member commissions. FDR tried to reframe them as executive power, and we now think of them as executive power. But before Humphrey's Executor, the whole reason why these things were allowed to have independence was because they weren't seen as wielding any executive power. So that's the other path the Roberts Court might take if they want to move forward with further reform. It's to roll back independent agency powers that are executive, right? So things like enforcement power, especially. You could see the court after Seila saying, no, independent commissions can't have those powers and retain their independence. That's quintessential executive power that has to be in the control of the president. There's always been debates in the administrative law community over what's called the split enforcement model, which is where one independent commission just makes the policies and adjudicates cases, and then another agency actually brings enforcement. There's some things in Seila Law that might give a foothold for litigants who want to bring things in that direction. Narrow, targeted strikes at the most quintessentially executive aspects of independent agencies' modern powers, to pull those things back. Obviously, I think that's not where the energy of the conservative and libertarian legal movement is. The zeitgeist really is for getting rid of independent agencies altogether, and maybe that's where the court will end up. But I would focus people's attention on this opportunity for narrower reforms, focusing on specific aspects of independent agency power.
I'm glad you went first, Adam, because that allowed me to check on the status of Collins versus Mnuchin, because it's been so long since, I think it was early last fall, that the Fifth Circuit en banc said that there were serious constitutional problems with the FHFA, the Federal Housing Fair Housing Federal. I don't remember what all these things stand for, but anyway, Mark Calabria, my former colleague, is now the director of it. And there was a split of authority among basically a conservatives versus liberals opinion, but a split of authority on severability and things like that. And cross petitions for cert have been pending at the Supreme Court since January. Presumably now what the court's going to do is grant vacate and remand for reconsideration in light of Seila Law. Slightly different structure in that agency, slightly different budgeting, and I don't know whether that's significant for the constitutional concerns that were raised in Seila Law. But there are other agencies that have not quite every jot and tittle of the expansive powers of the CFPB, but that structurally do look similar.
You know, one other interesting thing that followed this case was Elizabeth Warren tweeted, it was sort of a strange tweet. I'll probably write about it at some point. She said, "The CFPB continues to be an independent agency. Their job is to get the tricks and traps out of credit cards, mortgages, et cetera. Nothing in the Supreme Court ruling changes that." It's really kind of a strange tweet because obviously on its face, the whole point of the case was that the CFPB isn't an independent agency
Also
anymore.
classic Adam White to read a tweet off a piece of paper.
Oh, thanks. I print up all my emails too. But no, what's interesting about that is I think what she's getting at is this is a shout out to the bureaucracy of the CFPB, right? It's if not a dog whistle, it's a watchdog whistle. And it's a call to the bureaucracy of the CFPB to continue doing what they're going to do. Right? The most important independence regarding the CFPB was never really the independence between the leadership and the president. It was between the bureaucracy, which Elizabeth Warren and others installed in the first instance, which becomes rather self-perpetuating, and the political leadership. There's only so much political leadership can do to really run the agency. That's true for almost all agencies, but it's especially true for a young, sort of ideological, mission-oriented agency like the CFPB. And so I think that's what Warren is getting at. I think that's what people really ought to pay attention to is the independence within the agency. I think also it's a good reminder to conservatives and libertarians, right? We're very much accustomed in our world to calls to, well, as Steve Bannon put it, deconstruct the administrative state, get rid of agencies, and so on. The most successful reforms are almost always constructive, not deconstructive, right? Progressives building agencies like the CFPB. But on our side, on the conservative libertarian side, the greatest regulatory reform was the creation of OIRA as sort of an institutional check and balance against the other agencies. And I think one of the important takeaways from this entire experience really is that conservatives and libertarians ought to focus on constructing an unadministrative state and constructing institutions within government that are created for the precise purpose of checking and balancing the pro-regulatory side of things, right? Maybe a better version of the Small Business Administration, other things like that. Ultimately, the CFPB is a success story for Warren, right? It's not going away. And I think
Richard Cordray actually wrote a positive op-ed in the Washington Post about this decision, saying,
yeah.
"Hey, once Biden becomes president, then he'll appoint someone like me again, and we're off to the races again."
Right, and so I think that really is sort of it ought to be sort of a lesson for us. So there's only so much you can do through litigation to bring things down, and it is important. I mean, I've been in that business. Ilya's still in that business, but I think conservatives and libertarians really need to focus also on the construction side of things and learn from the CFPB example.
I think it's interesting that you bring up OIRA, or good that you bring up OIRA, because now that the CFPB is not, or at least answerable to the president, I think you'll see a lot more OIRA involvement with the rules and regs there. And so I think that is an important oversight that the administration will have. When Elizabeth Warren says, and this is back to my earlier point, when Elizabeth Warren says it's still an independent agency, it is definitely independent from Congress. Mm-hmm. And I actually, again, I think that's a very big problem. And it's like I said, it's hard to conduct oversight for Congress if they have no purse strings to pull. Even the other bipartisan commissions, all of them have some sort of appropriations that they have to go and answer to what they're doing at the agency, and the CFPB has none. Mulvaney said, and again, I was as a former congressional staffer on the Republican side, I was really excited for Mulvaney's first stint at the at the committees, and that Schadenfreude lasted all of about 10 minutes when I realized this is terrible. It's bad governance. It's bad policy. And so I think while it's good that more of the presidential administration will be involved, it is an independent agency in that it has nothing to answer for to Congress.
So if I can just ask Adam about this because he put a lot on the table there. It sounds like almost advocating a second derivative deep state, if you will, and multiplying OIRAs. My colleague Will Yateman at Cato has published a paper suggesting congressional OIRA, just lots more OIRA, lots more cost-benefit analysis, and all this other stuff. So is it, it's kind of a ratchet effect, and to counteract the ratchet, you kind of color the ratchet a different color without scaling back. And so ultimately we just get more and more barnacles. I mean, at a certain point, wouldn't it be easier to deconstruct rather than just add more bureaus checking other bureaus?
Wouldn't think of them as barnacles. No, but I think that, I mean, listen, there's a difference between you and me, right? You're the principled libertarian, and I'm sort of the warmed over New Dealer, good government guy.
I'm just a simple constitutional lawyer. I apply what I read on in the text,
But all I'm saying is that that one of the geniuses of the founding was that institutions matter, right? And you need checks and balances. And there's sort of an asymmetry in the way conservatives and libertarians approach this and the way progressives do. The progressives build institutions, they install them with sort of an expert class that's really insulated in a variety of legal and practical ways from political oversight, and they just trust that that's going to last longer. I shy away from the deep state term. I mean, sometimes they're not very deep at all, they're pretty shallow. But I'd say there is something to be learned from that, right? That you create institutions, as Justice Thomas once put it in an article before he was a justice, you create good institutions that embody good values, and you allow those institutions to play a role in government. And whether it's, OIRA, congressional OIRA, other things, or inspectors general, what have you, I'd say looking for opportunities to build institutions in the first instance and to really imbue them with mission and personnel, I think is a practical lesson that we ought to learn from the Elizabeth Warrens of the world. I saw, or Ashley, can I make reference to this question that's in the queue about Robert Moses? It's Peter Wynn has this question about the Robert Moses problem. I know it's trendy.
Can you read the question, please?
Oh yeah, or I don't mean to do your job. I don't mean to jump the queue here. Peter Wynn points out that the disconnect with the appropriation process parallels the Robert Moses problem. Robert Moses, the famous infrastructure czar in New York in the mid-20th century. Moses was appointed and in theory could be removed by the mayor, but his ability to self-fund allowed him to accrue so much power, no one dared ever to try to remove him. Under our federal constitutional structure, the power of the purse is the key limit on executive power. Is there any constitutional law addressing this kind of funding structure? Now, Ilya already alluded to this, and so is Beau, and I think I have too. Funding is a total blind spot in administrative law and the constitution of administrative law. And I think that we're going to see case law as progressives have sort of pushed this envelope so aggressively. I don't know about the CFPB case. The Supreme Court might decide that it's sort of said enough on this issue, but maybe elsewhere. We will see. But on Moses, I've heard that it's sort of trendy these days in the Zoom era for pundits to keep a copy of Robert Caro's Moses biography, The Power Broker, on the shelf behind you. Well, I can one up all these people because I keep it in arm's reach here on my desk because I think the best he's looking for his copy. I think that actually conservatives really ought to look back at the debate over Robert Moses. The left seems to assume, oh, you keep witness? Sometime we'll compare notes. I think the left sort of has this comfortable view of Moses that he was this sort of, corporatist figure who just quashed the little guy and who was out of control and above power. When actually Robert Moses was a proud progressive and New Dealer who came to New York and did what basically the CFPB and the EPA do today. They have a sort of an ideological mission they have a vision of where they want to push the American people, that they think the people will eventually thank them for it or would thank them for it if the people understood rightly their own interests. And they just push forward with this really technocratic and inhumane agenda. We see that sometimes in the CFPB, where they tried to protect the little guy, but really in many ways made it very hard for the little guy. I mean, I saw this with my client in our own case, this West Texas Community Bank, State National Bank of Big Spring, and their CEO, Jim Purcell, who the CFPB's sort of avalanche of regulatory red tape made it much harder for these people to serve their community in good faith the way that they wanted to. We see that in the impositions of the EPA in Rust Belt communities and elsewhere. And my point with all this is I think conservatives and libertarians would do well to really think about why it is that Robert Moses is such a villain, and to sort of point out to, or he's remembered as such a villain, and to really teach the American people about the Robert Moseses of our own time, which really are people like Richard Cordray and some of the recent heads of the EPA.
You know, I'm going to touch base or talk a little bit about a wonderful Cato scholar that talked about the necessary good that the CFPB could do, Todd Zawada. I know that's not really fair. He was at Mercatus when he wrote the piece, but one of the things, like, it's if you realize that the CFPB is here to stay, then making it work properly is the only thing that's good for consumers. You look at some of the regulations that they push. You talked about how they're trying to help the little guy, but they end up hurting the little guy. In the payday rule, because of the lack of robust cost-benefit analysis, they were able to publish that the consumers would lose 70% of availability of these loans, give or take. And they said that's a benefit. Well, there's nowhere. This is the bottom of the barrel. There's no other the last regulated lending source. There's nowhere else for them to go. But there is always a lender of last resort. It's just the first unregulated lender. And so that doesn't help. Pushing consumers down to loan sharks doesn't help. It doesn't help the little guy. The arbitration rule, they buried it in a footnote that if the arbitration rule were to pass, consumers, while there would be more money returned to consumers as a group, individually, consumers would go from receiving $5,400 in arbitration to $32 in class action lawsuits. That's not good for the little guy either. But these big regulations that make the powers that be feel good about themselves on protecting the little guy. If you have a structure that doesn't force robust and good analysis, then you're going to end up with more of these. And so I think creating mini OIRAs or economic banks within each administration ends up producing better policy. We're going through some struggles with the FTC right now, but I think on a whole, you don't hear a lot about the terribleness of the FTC rules, at least historically, because you've got that army of economists in there that are like analyzing every single thing that comes out. And I think that's a good thing.
I'll just associate myself with anything that Todd Zawada has said on this issue. He's not been able to speak out about this case because, although we do have back channel conversations, because he's on this advisory board now and maybe even the chairman. But anyway, he said that he'd be calling in after a faculty meeting right now. So Todd, if you're on the line or Zooming, feel free to pipe in with a question or something.
I just realized I'm missing a faculty meeting.
Yeah, Beau, I like that you bring up the anti-arbitration study. I thought that was one of the worst CFPB actions over the past, I think it was in 2015 or so. It was like 750 pages and mentions like 100 pages in that none of these went to trial. Are there any other, examples of things the CFPB has done in recent years, Beau, that you would like to kind of highlight as being important in this case and in cases going forward?
Well, I want to talk a little bit about some of the stuff that they've done since, and granted, to his credit, Cordray was the mind behind the original version of it, but Project Catalyst, which is basically a first run at a regulatory sandbox, gave Upstart an opportunity to do a little bit more creative things, and so as far as data for credit scoring, whether or not a consumer is a good bet based on things like if they call their mom regularly and talk more than 20 minutes, that is an indicator of good credit. We have this thing, this giant amount of data that's out there on consumers these days, and people are more than just their credit card and how much they pay their bills. Some people don't even have credit cards, and so that was his idea, and I think that kind of laid the groundwork for the current compliance sandbox. And that's one of the things that I think the CFPB could do and do well, is offer some additional creativity to technological products that could benefit consumers. I'm a little old for this, but I have friends that have no credit cards whatsoever. They do all their payments through Venmo, and some of them can't get cable contracts because they have basically no credit. And so allowing some creativity in the credit market, I think that's a good thing. And that's something that that the CFPB has done and is continuing to expand on, that I think was positive. There's a lot of negative out there too. You send an information request and all the wheels stop and the company is terrified and doesn't know how to answer. That's not positive. Stuff can just hang out there forever. And so I think this particular case will allow for at least a little bit more wariness on the part of the director. But in general, I think there's still a long way to go.
I'd point out two things that I think were particularly bad about the CFPB that might not have gotten as much attention, because I think they tell a broader story about the modern administrative state. One was the CFPB's ability to repay rules on mortgage lending and so on. I'm not sort of ideologically opposed to regulation or even federal regulation on that aspect of consumer finance. But I will say, and this is one of the things I learned from my client at the time, the West Texas Community Bank, the CFPB sort of approached this entire industry, including the community banks, with this sort of abstract mindset about exclusive use of quantitative models to determine ability to repay. Totally unfamiliar with the whole notion of what our client referred to as character loans, right? You might, somebody comes in from your community, you're serving that community, you know them, they might not be able to, on paper, they might not be able to make the numbers add up, but you're willing to make sort of a reasonable, I wouldn't say a bet, because community banks aren't really in the betting business, but you're willing to move in favor of a loan that might not make sense strictly as a matter of numbers, but because you know the person well. And the CFPB's initial rules made that almost impossible. And I thought it was an interesting mindset into this. Our client was the head of the Texas Bankers Association. They met with Cordray and invited him to come down, or invited his team to come down and just see how these people do business. And the CFPB bureaucrat said, we don't need to come down to see your bank. We know how banking works. Well, they do in sort of an abstract technocratic way, but not in a real way. And I thought that was an interesting window into a problem that's just so endemic in modern regulation. The other issue that I think didn't get enough attention was when the CFPB, in coordination with the Obama administration's Justice Department, really tried to put the squeeze on lenders for industries they didn't like, particularly the gun industry, trying to leverage their sort of nebulous power in financial markets to act as a shadow regulator on other issues by saying, well, if you banks do business with gun dealers, gun manufacturers, you're really bringing in reputational risk. And it was total bootstrapping. What they were saying was, we're gonna characterize these industries as monstrous, and if you continue to do business, then you'll be seen as monstrous too, and that wouldn't be very safe and sound from a banking perspective. I think that the CFPB's eagerness to really become a shadow regulator of these other industries showed how delicate and crucial, oversight of these financial regulators really are. We see that with respect to the SEC, when there was pressure on the SEC to get more involved in political disclosures or politicized disclosures. This is an area that I think really deserves a lot more attention, because to the extent that progressives feel dissatisfied in the policy outcomes they're getting through direct regulation, they're going to lean ever more heavily on financial regulators. And financial regulation has always been such a nebulous area of regulation to really indirectly control what they can't control directly.
I think to talk about, you're talking about Operation Choke Point. And the only reason that this really came to light was because the FDIC was also involved. Had the FDIC not been involved, it might have lasted longer than we would have expected because there is no opportunity for additional oversight. The people that are at the CFPB at the time were tight-lipped, and they were on Team Richard Cordray, and there's no whistleblower, and so in some respects, consumers got lucky. It's across the board that they were being leaned on. It wasn't just guns; it was payday lenders. It was basically any political unfavorably political organization, fireworks of all things. It was the laundry list was huge, and just happened that the FDIC was also involved, and that was what broke the dam.
Did we have any more questions from the audience now that I can ask questions without my dog interrupting? I'm sorry about that. Happens. See, do we have anything else in the Q&A? And if not, do we have any quick closing thoughts?
Thank you.
I'll just say that this was pretty much what people were expecting. This was the conventional wisdom result. I was hoping for a little more leading up to it. We got, I guess, 2 votes against Humphrey's executor, 2 votes against treating severability doctrine a little differently. But that's, I think, we say that sort of thing with just about Gorsuch and Thomas across a whole range of areas. So I don't know how much more movement there is going to be on structural challenges per se. So forgetting kind of the theoretical purity, Adam's approach about actually legislating solutions has some practical attractiveness to it.
Well, I mean, in response to that, I would just add, or on top of that, that some of the most important reforms of administrative law that we've seen in the last few years have been, small steps. They've been led by Chief Justice Roberts. The biggest rollback of Chevron deference was the front end of his opinion in King v. Burwell. He's made significant reforms to our deference in the recent Kaiser case. He's drawn lines around Humphrey's executor and so on through Free Enterprise Fund and now Celia. Obviously, there are a lot of areas where I hope the court goes further. I think it should go further as a matter of first principles. But I think we really ought to celebrate the wins when they come. These are significant efforts to really put a lot of old precedents, in a tighter box and really put the burden on the defenders of those precedents to come up with principled justifications for them. And I'm hopeful that we'll continue to see at the very least, step-by-step reforms, including maybe the ones I referred to earlier about taking away some pure executive powers from these multi-member commissions by being really honest with the limits of Humphrey's executor as it was originally understood and not the sort of blob it became over the subsequent 70 years.
Or perhaps a reinvigoration of the non-delegation doctrine and force Congress to make more of those kinds of decisions.
I would be up for that. Yeah.
On that note, it is going to fall to Congress, which I celebrate the win in the case, and it did. There were lots of good things in the opinion, but to see Richard Cordray come out and spike the football afterwards, that's concerning to me, and that just kind of really keyed up the fact that Congress isn't done with this agency, or at least shouldn't be. I think some reformers there was appetite for bipartisan reform on both houses of Congress, 3 years ago, that has evaporated because now it's like, oh, my guy's going to be in charge again next year, and I think that's problematic, and that's problematic for the future of the agency, and honestly for consumers. When there's no long-term structure certainty in a regulator, there's a lack of innovation. Consumers have less opportunities. And so I think there should be concerted effort in Congress to do a little bit more reforming of the agency as well.
Okay, unless there are any more questions, I don't see any. I think that's about all we have for today. Thank you to our panelists for coming out. For those of you who tune in regularly or would like to next week, we're not sure about our topic next week, but it'll probably be something related to the remaining Supreme Court decisions. There are only a few left. There's an orders day is on Monday, so we'll see what the court hands down then. And then we'll be having our webinar as usual on Thursday. And thank you for tuning in. Have a great day.
Thank you.
Thank you.
Thanks. Thank you to our panelists.